Imagine you are sitting in a courtroom,
Okay.
and to your left is a 14-year-old kid. Biologically speaking, their brain is still heavily under construction, right?
Right, definitely.
Like, it is physically incapable of fully grasping long-term consequences or, resisting peer pressure.
Yeah, the science is pretty clear on that now.
Exactly. But then, to your right, is this vast, incredibly powerful legal system. And that system looks at that exact same kid and basically says, we don't care about your biology. We are locking you up for the rest of your life anyway.
It's a heavy thought.
It really is.
Yeah.
Today, we are exploring one of the most, contradictory, messy, and fascinating corners of American law.
Yeah, it's a corner of the law that has been caught in this sort of tug of war for over a century now.
100%.
Because the fundamental question we're looking at today is, how should a society respond when the criminal is a child and the child is a criminal?
Right. And to understand how we actually arrived at our current heavily fractured system, we are taking a deep dive into a really foundational text.
Yes, we are.
It's called The Evolution of the Juvenile Court: Race, Politics, and the Criminalizing of Juvenile Justice. And it's by Barry C. Feld.
And our mission for this deep dive is to basically trace the complete 100-plus year journey of the juvenile justice system.
Which is a lot of ground to cover.
It is, yeah. But Feld's book is great because it doesn't just give us a dry timeline. It gives us this really sharp diagnosis of how we treat our youth.
Right.
He breaks this massive history down into 4 distinct eras. So we have the progressive era, the due process era, the get tough era, and finally the contemporary era, which is often called the kids are different era.
I like that structure. It makes it easier to digest.
Yeah, and a crucial piece of the framework the author uses is treating the juvenile court as what sociologists call a dependent variable.
Wait, a dependent variable, like from high school science?
Basically, yeah.
Yeah.
Meaning the court doesn't just exist in a vacuum completely insulated from the outside world.
Okay, I see.
Right. Instead, the court's structure, its function, its whole underlying philosophy, it constantly morphs and adapts based on macro-level societal shifts.
So we're talking about things like massive changes in the industrial economy.
Right. Exactly. Waves of urbanization, shifting racial demographics, and the really powerful currents of political strategy.
Okay, let's unpack this. Because before we can understand how the current system broke down, we kind of have to understand the idealistic blueprint it was built on in the first place.
Right. You have to go back to the beginning.
Yeah. So let's travel back to the late 19th century, 1899 to be exact, in Chicago, Illinois.
A very busy time and place.
Oh, incredibly busy. If you were walking the streets of Chicago back then, you'd be totally overwhelmed. I mean, you have the smell of the massive meatpacking stockyards. You have these factories just belching smoke everywhere.
And the tenements, right? Just incredibly overcrowded tenements.
Yes, exactly. The country was undergoing this profound shock to the system. America was rapidly transitioning from a very rural, agrarian society into this urban industrial powerhouse.
Yeah, railroads were creating massive national markets, and you had millions of immigrants from Southern and Eastern Europe just pouring into Eastern and Midwestern cities looking for factory work.
Right. And amidst all that chaos, the actual literal concept of childhood was mutating.
Which is wild to think about.
It is. Because on those rural family farms back in the mid-1800s, kids were essentially viewed as miniature adults.
Right, they were workers.
Yeah. The moment a child was physically capable of picking crops or tending livestock, they were just integrated into the adult economic reality.
There really wasn't a distinct multi-year phase of adolescence where you were sheltered from the real world.
No, not at all.
That idea of childhood as a distinct, vulnerable developmental stage is actually a surprisingly modern social construct.
It really is.
As the Industrial Revolution created this new, comfortable middle class in the cities, parents suddenly didn't need their children to work the fields anymore.
Right. They had the luxury of time.
Exactly. They began investing more time and resources into preparing their children for complex adult roles, mostly through education.
Yeah.
So children became viewed as innocent, dependent, and requiring special, prolonged supervision.
Enter the progressive reformers.
Ah, yes. The child saber.
That's what the history books often call them, right? These were largely middle-class and upper-class women, figures like Jane Addams and the women of the Hull House in Chicago.
Right.
They look out at these booming, chaotic cities filled with poor immigrant youth who are roaming the streets, getting into trouble, and they want to do something about it.
They wanted to fix it.
Yeah. So in 1899, in Cook County, They pushed the legislature to create the very first juvenile court. But, and this is key, they didn't want it to look or feel like a normal legal arena.
No, not at all.
I like to think of their vision of this court as being much closer to a hospital.
That hospital comparison gets right to the heart of their philosophy. The progressive reformers were heavily influenced by this new scientific movement at the time called positivist criminology.
Positivist criminology. Okay, break that down for us.
Sure. So prior to this, the dominant legal theory was classical criminology, which basically said that human beings have total free will, and if someone commits a crime, it's a calculated, rational choice to do evil, and they must be punished proportionally.
An eye for an eye, basically.
Right. But positivist criminology threw that completely out the window.
Because the positivists looked at crime as a symptom of a disease, right?
Exactly. They believed human behavior was determined by external forces. So they didn't look at an immigrant youth who stole a loaf of bread and see a morally culpable criminal acting on free will.
They saw a victim of a sick environment.
Yes. They blamed the poverty of the slums, the supposed moral failings of the immigrant parents, and the corrupting, filthy influence of the industrial city itself.
And if crime is a disease caused by the environment, well, you don't throw the kid in a brutal adult penitentiary to rot.
Right. You diagnose the social illness and you cure it.
So how did they legally justify stepping in like that?
To do that, they built this entirely new justice system on an old English legal doctrine called parens patriae.
Parens patriae.
Yeah, historically, this was a concept where the British Crown acted as the ultimate guardian for orphans or heirs to vast estates, mostly just to protect their property.
Right.
But the progressive reformers repurposed it. Parens patriae became the legal justification for the state to step in and act as a super parent for delinquent kids.
A super parent. I like that term. And the court basically had two main goals here, right? Diversion and intervention.
Exactly. First, divert kids away from the horrors of adult criminal courts.
Which were truly horrible back then.
Oh, awful. Back then, if a 12-year-old was caught stealing, they were thrown into a jail cell with hardened adult criminals. The reformers wanted to stop that entirely. And second, they wanted to intervene in these children's lives to actually rehabilitate them.
Because the court was viewed as this benevolent welfare agency, literally a clinic to help sick kids, the founders completely stripped away all the standard criminal procedural safeguards.
Which is where things start to get tricky.
Yeah, let's talk about what that actually looked like in practice. Because if a kid was dragged into this new juvenile court, they didn't get a defense lawyer.
Nope, no lawyers.
There was no jury of their peers. There were no strict rules of evidence. Like, hearsay was totally fine.
It was incredibly informal.
Right. It was just the child, maybe a probation officer, and a specialized judge sitting around a table having a supposedly informal fatherly chat.
What's fascinating here is the underlying assumption. The reformers assumed that because the state's intentions were purely to help the child didn't need any legal protections from the state.
That is a wild assumption.
I mean, if a doctor's trying to give you medicine, you don't bring a lawyer into the examining room to cross-examine the doctor. They viewed constitutional rights as unnecessary, adversarial barriers that would only get in the way of open communication and effective treatment.
Okay, I have to pause here, though, because looking at the reality of those early courts, it wasn't just a happy, helpful hospital for everyone.
Not at all.
If this was all about benevolence and protecting the innocent, why does Feld's book highlight so much intense, targeted discrimination right out of the gate?
Yeah, the progressive vision had a profoundly dark underbelly. You really have to consider who the child savers were and who they were targeting.
Okay.
The reformers were overwhelmingly upper and middle class Anglo-Protestants. But the youth being brought into these new courts were almost entirely the children of poor, working-class, Southern and Eastern European immigrants.
We're talking Catholics, Jews, Italians, Poles.
Exactly.
This brings up that other people's children concept from the text. The reformers wouldn't have treated their own kids this way, right?
No, of course not. The court was explicitly designed as a tool of social control. The goal was to assimilate and Americanize these immigrant children.
To kind of strip away their culture.
Pretty much. The reformers viewed the culture, the languages, and the child-rearing practices of these immigrant families as inferior or even dangerous to American democracy. So the juvenile court became a mechanism to force middle-class Protestant values onto the urban poor, all under the guise of rehabilitation.
Wow. And if we look at the racial dynamics at the time, the discrimination is even more glaring. Like, where were the black children in this grand citizen-building vision of the juvenile court?
They were systematically excluded.
Completely.
Almost entirely. At the turn of the 20th century, the vast majority of black Americans still lived in the rural South. And in the Jim Crow South, the justice system was entirely dictated by white supremacy.
Right.
Their rehabilitative, paternalistic mission of the juvenile court was simply not extended to black youth. White criminality was viewed as a social problem to be cured.
But black criminality.
It was viewed as an inherent flaw to be punished and exploited. Black children were routinely subjected to adult criminal courts, sent to brutal adult prisons, and leased out as labor on chain gangs.
God, that's horrific. So the system was literally built on a foundation of exclusion from day one.
It really was.
And we also need to look at how this early court targeted young women, right? The book details how the court heavily utilized something called status offenses to explicitly police young girls.
Yeah, a status offense is an incredibly broad legal category. It basically refers to an act that is only considered a violation because of the youth's status as a minor.
So we aren't talking about stealing cars or assaulting people.
No, we are talking about truancy, running away from home, breaking curfew, or the incredibly vague charge of being incorrigible.
And how did that specifically impact girls? Like, why were they targeted more for that?
Well, the progressive reformers harbored strict Victorian moral sensibilities. They were terrified of the changing social dynamics in the cities. Specifically, young, working-class women gaining independence, going to dance halls, and mingling with boys.
Ah, okay. The scandal of it all.
Right. So the courts weaponized status offenses as a sort of euphemism to regulate girls' sexuality and enforce Victorian morality. A girl might be arrested and sent to a reformatory for immorality simply because she was caught riding in a car with a young man.
Wow.
Meanwhile, boys were almost never policed for similar behavior.
So we have the foundation of the juvenile court laid down by the 1920s. It's built on this idealistic concept of a superparent judge diagnosing social ills, but the reality is deeply infected from day one with class, race, and gender biases.
Exactly.
And the power of that judge is absolute, which naturally sets the stage for a massive collision, bringing us to the second era. Feld outlines the due process era.
Yeah, that collision was entirely predictable. Absolute discretion without legal safeguards inevitably leads to abuse. A benevolent dictator is still a dictator,
Right.
To understand the due process era, we really have to look at the massive demographic shifts following World War II.
Okay, so we're talking about the Great Migration.
Yes.
Millions of African Americans moved out of the rural South and headed to the urban North and West. They were fleeing the terrorism of Jim Crow and seeking the booming industrial jobs in cities like Detroit, Chicago, and Philadelphia.
But the reality they met in the North was just another form of segregation.
Right.
You had federal housing policies, banking practices like redlining, where banks literally refused to lend money to people in certain neighborhoods, and white flight to the suburbs.
All of which meant that these newly arriving black families were forced into heavily segregated, under-resourced urban ghettos.
Exactly. And as the populations of these cities changed, Black Americans began facing the reality of the Northern justice systems, including the juvenile courts. And this increased urbanization placed racial equality and civil rights squarely on the national political agenda.
Which brings us to the 1960s, the height of the civil rights movement, and crucially, the era of the Warren Court.
Right, under Chief Justice Earl Warren.
Under Warren, the Supreme Court embarked on this constitutional revolution. They began actively addressing racial inequality and limiting the arbitrary power of state institutions through strict enforcement of criminal procedure.
The Supreme Court is basically going state by state, institution by institution, demanding that constitutional rights be respected.
Right.
And eventually, their gaze lands on the juvenile court. They start looking at what is actually happening behind the closed doors of these so-called hospitals.
And what did they find?
They found a mess, and that leads to a massive earthquake of a case in 1967 called In re Gault.
Oh man, Gault.
Yeah.
Gault is arguably the most important juvenile justice case in American history. It completely pulled back the curtain on the whole system.
The court looked at the reality of juvenile courts and realized that the sweet, rehabilitative rhetoric of the progressive era was often just a mask.
Yeah.
It was a system that routinely locked kids up in terrible, abusive state institutions without anything resembling a fair trial.
Let's actually look at the details of the Gault case for a second, because it perfectly illustrates how insane this system had become.
We really should.
We're talking about a 15-year-old boy named Gerald Gault in Arizona.
Right?
and was his massive crime. He and a friend made a prank phone call to a neighbor, a Mrs. Cook. They allegedly made some lewd remarks.
By today's standards, it's just a minor nuisance.
Exactly. But the police showed up at Gerald's house, arrested him, and took him to a detention facility without even leaving a note for his parents.
His mother literally had to go searching for him.
And the hearing itself was a total farce. Mrs. Cook, the woman who received the call, didn't even show up to testify.
No.
Gerald wasn't provided a lawyer. There was no transcript of the hearing at all.
The judge just questioned Gerald directly, and based on that brief, informal chat, the judge committed Gerald to the State Industrial School until he turned 21.
Until he turned 21. Think about the math on that. A 15-year-old sentenced to up to 6 years of incarceration for a prank phone call.
It's staggering.
If an adult had made that exact same phone call, the maximum penalty under Arizona law at the time was a fine of $50 or 2 months in jail.
The disparity is just mind-blowing. So the Supreme Court looked at that and finally said, enough. The benevolent superparent model is failing.
Right.
The court noted the massive disjunction between the theory of rehabilitation and the punitive reality of these industrial schools, which were basically just prisons for kids.
So what did the court actually do in the Galt decision?
Well, they finally granted children some basic, fundamental constitutional rights in delinquency hearings. They mandated the right to counsel, the right to formal notice of the charges against them, the right to confront and cross-examine witnesses, and the privilege against self-incrimination.
Basically the Miranda rights for kids.
Essentially, yes.
And the dam broke after that, right?
Okay.
The decision just kept coming over the next few years.
They did.
In a case called Winship, the court tackled the burden of proof. Because before Winship, a juvenile judge could lock a kid up using a really low civil standard.
Right. Basically just saying, I think it's more likely than not that you did it.
Which is wild. But Winship required the state to prove a youth's guilt beyond a reasonable doubt, which is the exact same high bar required in adult criminal trials.
And shortly after that, a case called Breed applied the protection against double jeopardy to juveniles.
Okay, for the listener who might only know that term from the movie or the game show, how does double jeopardy apply here?
Good point. Double jeopardy is the constitutional rule that the government cannot prosecute you twice for the same crime.
Right.
Before Breed, a juvenile court could hold a full hearing, find a kid guilty, and then, if the judge felt like it, transfer the kid to adult court to be tried and punished all over again for the exact same offense.
That seems so obviously unfair.
It was, and the Supreme Court finally said that practice was unconstitutional.
So, on paper, this looks like a massive victory for civil rights. I mean, the Supreme Court is forcing this rogue informal system to adopt the rigorous adversarial procedures of a real legal institution. Kids finally have lawyers fighting for them.
It was a victory, absolutely, but it created a profound unintended paradox.
How so?
Well, the due process era essentially forced the juvenile court to abandon its purely welfare agency model. But by injecting lawyers, formal charges, and the standard of beyond a reasonable doubt, the juvenile courts suddenly started looking and acting almost exactly like adult criminal courts.
Ah, I see where this is going. If you demand a lawyer in a formal trial, the system stops viewing you as a vulnerable, sick child in need of a hospital.
Exactly.
They start viewing you as a competent, adversarial defendant standing trial.
That is the tragic irony of the due process revolution. By making the court procedures more criminalized, it became culturally and legally much easier to justify punishing kids like adults.
Right, because if the trial looks the same, why shouldn't the punishment be the same?
Exactly. And to make matters worse, the Supreme Court didn't even go all the way. They stopped halfway down the road to full constitutional protection. We really have to talk about the McIver case.
Right. McIver v. Pennsylvania in 1971. This is the glaring exception to the due process era.
It really is.
Because after granting the right to a lawyer and the strict burden of proof, the Supreme Court was asked if juveniles also had the constitutional right to a jury trial. And the court point-blank refused.
Which is baffling.
Why? If they just spent years dismantling the informal system because it was abusive, why deny the ultimate protection of a jury?
Their reasoning was highly contradictory and frankly driven by administrative fear. The justices claimed that injecting a jury into the process would destroy the informal protective proceeding of the juvenile court.
Wait, they just spent the Galt and Winship decisions saying the informal protective proceeding was a myth. They can't suddenly hide behind it just to save time and money.
You'd think so, but they were terrified that requiring juries would completely clog up the juvenile system, making it too slow and too expensive. Legal scholars heavily criticize McIver for that exact hypocrisy.
Understandably.
By denying the right to a jury trial, the Supreme Court left children with the absolute worst of both worlds.
They were now subject to increasingly criminalized, adversarial trials and punitive sentences. But they were denied the ultimate constitutional protection, a jury of their peers,
Right.
to ensure accurate fact-finding.
Right. They were left completely at the mercy of the judge.
It's a total trap. The juvenile court lost its protective, paternalistic shield, but it didn't gain the full armor of the adult criminal court.
Exactly.
And that vulnerability leads us directly into the third era Feld analyzes, which is undoubtedly the darkest chapter in this history, the Get Tough era.
Yeah, the transition into the Get Tough era in the 1970s, 80s, and 90s didn't happen in a vacuum. It was driven by a massive, volatile combination of economic collapse, changing drug markets, and political opportunism.
Let's set the economic stage first. The industrial boom that had drawn millions of African Americans to northern cities during the Great Migration, it began to collapse.
Right.
Deindustrialization swept the country, the factories closed down, the manufacturing jobs moved overseas or out to the suburbs, and the inner cities were essentially gutted.
You were left with a deeply impoverished Black underclass trapped in urban areas of concentrated structural poverty.
And into that environment of economic devastation, a new catalyst was introduced in the 1980s, crack cocaine.
The crack epidemic completely destabilized these communities, and it brought with it a massive proliferation of illegal firearms as rival groups fought these vicious turf wars over the incredibly lucrative drug markets.
The violence was very real. We saw a terrifying, undeniable spike in youth homicide rates during this period, particularly among young Black males in urban centers.
It was a crisis, but it is at this point in our deep dive that I think we need to clearly frame how Feld approaches the political reaction to this violence.
Oh, definitely. I want to pause here for a second just to make something really clear for you listening. We are looking at historical political strategies from the late 1960s through the 1990s.
Right.
Feld specifically examines how politicians, particularly leveraging the Republican Southern strategy, utilize these social crises. We are not taking a political side or endorsing these historical interpretations. We are merely objectively reporting the author's academic analysis of how race and politics influence legal policy during this era.
Exactly. It's fascinating to look back objectively at how political rhetoric is crafted because, regardless of your political affiliation, the historical record shows that crime became an incredibly effective wedge issue to win elections.
Right, the rhetoric completely shifted. Back in the progressive era, we said crime was a symptom of a sick society.
Yeah.
But in the Get Tough era, the narrative flipped entirely.
Politicians began arguing that crime was not a result of structural poverty or economic collapse. They said it was a personal, moral failing. It was a failure of individual character.
And Feld details how political campaigns increasingly utilize coded language, right?
They crafted rhetoric that conveyed a clear racial message to anxious suburban voters without using explicitly racist terms.
Like what?
Well, they spoke endlessly about law and order, welfare queens, and urban thugs. They manipulated public fears, effectively shifting the blame for urban decay away from the massive loss of manufacturing jobs and onto the individuals trapped in those decaying neighborhoods.
And nowhere was this fear-mongering more apparent and more destructive than in the creation of the super predator myth.
Oh, the super predator myth.
This wasn't just politicians either, right? This was academics and the media actively throwing gasoline on the fire.
Yeah, the most prominent figure here was a political scientist named John DiIulio. In the mid-1990s, he published articles warning of a coming wave of super predators.
What exactly did he mean by that?
He described them as fatherless, godless, and jobless youth who were fundamentally different from previous generations. He painted this picture of cold-blooded, remorseless killers who killed, robbed, and maimed without a second thought.
He literally predicted a bloodbath of youth violence was just around the corner.
He did.
And the media just ran with it. I mean, Time Magazine, Newsweek, the Nightly News, they were flooded with images of young, predominantly Black men in handcuffs.
They were framed not as misguided teenagers, but as sociopathic monsters entirely beyond rehabilitation.
It was a classic moral panic. And the irony is, DiIulio's demographic predictions were completely mathematically flawed.
They were completely wrong. The wave of violence he predicted never happened. In fact, youth crime rates began drastically dropping shortly after he published his theories.
But the damage was already done.
Exactly. The panic provided the perfect political cover for lawmakers to preemptively dismantle the protective foundations of the juvenile court. They shifted the entire philosophy of the system from rehabilitation to pure retribution.
Let's look at the concrete legal changes that happened during this panic. The rallying cries for politicians were things like adult crime, adult time, or if you're old enough to do the crime, you're old enough to do the time.
Catchy but devastating in practice.
And they made that a reality through transfer laws.
Right. Transfer laws are the mechanism used to rip a child out of the juvenile justice system and place them into the adult criminal court system to face adult prison sentences.
And during the Get Tough era, nearly every state in the country passed laws, making it drastically easier to transfer kids.
And crucially, it wasn't just about making it easier. It was about who got to make the decision.
Right. Historically, a judge would hold a hearing, look at the kid's psychological profile, their family history, and evaluate their amenability to treatment before deciding to transfer them.
But politicians didn't trust judges anymore. They viewed them as too soft. So legislatures shifted that immense power directly to prosecutors.
That seems like a huge conflict of interest.
It is. They created direct file laws where a prosecutor could choose to charge a child directly in adult court without ever seeing a judge.
Wow.
They also created statutory exclusion laws, which automatically stripped the juvenile court of jurisdiction for certain crimes. So if a 16-year-old was charged with robbery, the law simply declared they were an adult for the purposes of the trial, completely ignoring their actual age, maturity, or cognitive development.
And even if a kid managed to avoid transfer and stay in the juvenile system, the penalties inside that system became draconian. States threw out the old model of individualized, indeterminate sentencing.
Let's clarify that for the listener really quick.
Go for it.
Indeterminate sentencing was the progressive model. A judge would say, I'm sending you to the reformatory until you are cured. It could be 6 months, it could be 3 years. The release was based on rehabilitation.
But during the Get Tough era, states moved to determinate sentencing and mandatory minimums. If a kid committed a specific offense, the statute said they must serve exactly X number of years, period. The judge had no discretion to be lenient.
The juvenile court effectively became a second-rate criminal court, handing out fixed punishments but still denying kids the right to a jury trial.
The impact of these policies was catastrophic and, as Feld forcefully stresses, profoundly racially disparate.
Study after study from this era showed that Black youth were transferred to adult courts, detained before trial, and incarcerated at vastly higher rates than white youth who committed the exact same offenses.
It's just undeniable.
The system relentlessly penalized children of color, treating white youth as salvageable and Black youth as disposable.
And this punitive zero-tolerance mindset didn't just stay confined to the courthouses, did it?
No, it didn't.
It bled directly into the hallways of the public school system. Feld draws a direct causal line between the Get Tough juvenile policies and the creation of the school-to-prison pipeline.
Public schools have always had an element of social control, but the 1980s and 90s completely transformed the environment. A major catalyst was a Supreme Court decision in 1985 called New Jersey v. TLO.
This is a fascinating case.
Yeah.
A 14-year-old girl, TLO, was caught smoking a cigarette in the school bathroom.
Right.
The vice principal searched her purse to find the cigarettes, but while searching, he found marijuana, rolling papers, and a list of students who owed her money. She was charged with dealing drugs.
Her lawyers argued that the vice principal violated her Fourth Amendment rights against unreasonable search and seizure because he didn't have a warrant or probable cause to dig through her purse.
But the Supreme Court ruled against her.
They did. They severely lowered the constitutional protections for students inside a school building. They ruled that school officials only need reasonable suspicion to search a student, which is a much lower, more subjective bar.
Now, combine that lower legal standard with the raging moral panic over superpredators.
School administrators were terrified.
Exactly. So they adopted rigid zero-tolerance policies. A kid books a butter knife to school by accident, expelled. A kid gets into a shoving match in the hallway, arrested.
Schools brought in armed police officers, known as school resource officers, to permanently patrol the hallways. They installed metal detectors and surveillance cameras. They effectively criminalized normal adolescent misbehavior.
Instead of sending a disruptive kid to the principal's office for detention, they were putting them in handcuffs and feeding them directly into the juvenile justice system.
And again, this policing disproportionately targeted urban Black males. They were treating students like potential criminals to be contained rather than children to be educated.
The entire Get Tough era was just defined by punitive exclusion. It was a total society-wide repudiation of the idea that children are different from adults. It was incredibly bleak.
It was.
But the pendulum of history always swings, and that brings us out of the darkness and into the fourth and current era Phil describes. The kids are different era.
Yeah, and the shift into this current era wasn't driven by some sudden moral awakening among politicians. It was driven by hard science.
Science finally catching up with the law.
Exactly. While the Get Tough era relied on the absolute fiction that teenagers were just as criminally culpable and fully formed as adults, by the early 2000s, medical technology finally entered the chat and forced a massive legal reversal.
We are talking about the explosion of neuroscience. Through advanced brain scanning technologies, specifically functional magnetic resonance imaging, or fMRI, neuroscientists were finally able to physically map how the human brain matures over time in living subjects.
To understand why fMRI was such a game changer, you really have to know how it works. Unlike an X-ray that just takes a static picture of bone, an fMRI measures blood flow and oxygen levels in the brain in real time.
So you can see the brain in action.
Exactly. When a specific part of the brain is working hard, it draws more blood. So scientists could put teenagers inside these scanners, give them tasks involving risk, reward, or emotional regulation, and literally watch which parts of their brains lit up compared to adults.
And what they found proved what parents have known anecdotally since the dawn of time.
Yeah.
The adolescent brain is fundamentally, structurally different from an adult brain.
Feld's book relies heavily on a brilliant analogy to explain this neurological gap.
The car analogy.
Yes, think of a teenager's developing brain as a car.
Okay, so the accelerator of this car is the limbic system. That's the evolutionary older part of the brain, deep inside, that processes emotions, craves rewards, and seeks out novelty and peer approval.
Right.
During puberty, that limbic system matures rapidly. The accelerator is fully formed, incredibly sensitive, and extremely powerful.
But the brakes of the car are located in the prefrontal cortex, right behind your forehead. This is the area responsible for executive functions: impulse control, long-term planning, anticipating consequences, and weighing risks.
And the fMRI scans proved conclusively that the prefrontal cortex is still heavily under construction during adolescence.
Exactly. The neural pathways are not fully insulated or efficient yet. The brakes simply don't fully mature until a person is in their early to mid-20s.
So you have a teenager driving a high-performance sports car with a brick glued to the gas pedal and basically no brake pads.
It perfectly explains real-world teenage behavior. Think about a teenager at a party who gets dared to jump off the roof into a swimming pool.
Okay.
An adult looks at that and immediately calculates the risk. If I slip, I break my neck, I can't work, my life is ruined. The brakes engage.
But the teenager's brain processes it entirely differently. The limbic system sees the immediate reward, the thrill, the laughter, the peer approval, and the accelerator floors it. The prefrontal cortex isn't fast enough or strong enough to hit the brakes before they jump.
And while jumping into a pool is a relatively low-stakes example, when you apply that exact same neurological dynamic to a stressful, high-stakes environment involving drugs, fear, or weapons, you get tragic criminal behavior.
Crucially, defense attorneys and advocates took this hard science directly to the United States Supreme Court.
Oh.
And the data was so undeniable that it fundamentally altered the court's jurisprudence.
It led to a trilogy of landmark decisions in the 2000s and 2010s that reestablished, as a matter of constitutional law, that children are different.
Let's walk through that trilogy. First up was Roper v. Simmons in 2005. This case involved Christopher Simmons, who committed a horrific murder when he was 17 and he was sentenced to death.
In Roper, the Supreme Court officially and categorically banned the death penalty for anyone under the age of 18.
Wow.
Justice Kennedy wrote the opinion, and he explicitly cited the developmental psychology and neuroscience. The court laid out 3 specific reasons why juveniles cannot be classified among the worst of the worst offenders who deserve execution.
First, they have immature judgment and a lack of self-control. Second, they are highly susceptible to negative peer influences and outside pressures. They don't have the autonomy to just walk away from a bad situation.
Right.
And third, their personalities are transitional. A teenager's character is not fully formed yet. They have a massive capacity for change and rehabilitation as their brain finishes growing.
5 years later, the court expanded this logic in Graham v. Florida. They ruled it is unconstitutional to sentence a juvenile to life without the possibility of parole for a non-homicide crime.
But recognizing that if they haven't taken a life, they deserve a chance to grow up and get out.
Exactly. The court recognized that because of their neurobiological immaturity, a youth's criminal responsibility is doubly diminished when they haven't actually taken a life.
And the final piece of the trilogy was Miller v. Alabama in 2012. This case tackled the kids who did commit murder. The Supreme Court banned mandatory life without parole sentences for youths convicted of homicide.
Note the word mandatory there. The system can no longer just look at a statute and auto-sentence a 15-year-old to die in prison. Judges are now constitutionally required to hold an individualized hearing. They must look at the specific child, factor in their chaotic home life, the peer pressure involved, and crucially, the neuroscience of their diminished culpability before they can hand down that ultimate sentence.
These rulings systematically dismantled the most draconian punishments of the Get Tough era. They affirm that because youths lack mature brain development, they simply cannot be held to the same level of moral blameworthiness as adults. The Eighth Amendment forbids it.
It was a massive course correction, but it leads us to a really fascinating legal paradox.
Right, because if you listen to all of that, you might think, wow, the Supreme Court gets it. The science saved the day. The system is fixed.
Yeah, you would think that.
But it absolutely is not. The system is currently operating with a glaring, unresolved hypocrisy that legal scholars call the competence gap.
The competence gap is the contradiction between how the justice system treats a youth's brain at the end of the legal process versus the beginning of the legal process.
Okay, break that down.
Well, as we just discussed, the Supreme Court openly admits that kids lack adult judgment when it comes to punishment. They are too impulsive and immature to be executed or automatically locked up forever.
Right.
But at the exact same time, police and prosecutors turn around and treat those exact same teenagers as fully functioning, hyper-rational adults when it comes to legal competence.
Think about a 15-year-old sitting in a sterile police interrogation room. Two armed detectives are lying to him, pressuring him, using complex psychological tactics.
It's terrifying even for an adult.
Exactly. But the system expects that teenager, with his wildly spinning limbic system and under-construction prefrontal cortex, to perfectly understand his Miranda rights. They expect him to fully comprehend what it means to legally waive his right to remain silent, a concept many adults don't even grasp.
And the gap extends to the courtroom itself. We expect these neurologically vulnerable kids to sit beside a lawyer and make incredibly complex, strategic decisions about plea bargains. We expect them to navigate a highly adversarial court system.
And we must remember the ghost of the McIver decision.
Yes, the lack of jury.
We expect them to navigate this complex legal machinery without the protection of a jury trial to evaluate the evidence against them. The science definitively proves they are cognitively vulnerable. But the system aggressively exploits that vulnerability during interrogations and trials to secure convictions, only to suddenly acknowledge their youth when it's time for sentencing.
It is maddening. We admit the brakes don't work, but we penalize them for crashing the car anyway.
That is exactly it. Which brings us to the final act of this deep dive, the epilogue.
The path forward.
Right. We've traced the history, we've seen the biases, we understand the neuroscience, and we see the current contradictions. Furthermore, youth crime rates have plummeted from their peaks in the 1990s. The panic is over. So what is Feld's vision for actually fixing this broken machinery?
Feld argues that right now we are sitting in a unique historical window of opportunity.
How so?
The dramatic drop in crime reduces the political hysteria that fueled the Get Tough era. The neuroscience provides an undeniable empirical foundation for reform. And massive philanthropic organizations, like the MacArthur Foundation, have spent the last 2 decades heavily funding evidence-based policy research.
So the stars are aligning.
Basically. And based on all of this, Feld distills several concrete structural policy prescriptions.
Let's run through the major ones. First, the author proposes the implementation of a formal youth discount.
Yeah.
How would that actually work in a courtroom?
A youth discount is a formal statutory system of fractional sentencing based on age.
Fractional sentencing.
Right. Right now, if a judge wants to be lenient on a kid, it relies entirely on that judge's subjective discretion, which we know is often tainted by racial bias. A youth discount legally mandates leniency.
Give me an example of the math on that.
Sure. For example, a statute might say that a 14-year-old convicted of a crime receives only 25% of the adult sentence. A 16-year-old receives 50%. An 18-year-old receives 75%. It directly mathematically ties the severity of the punishment to their scientifically proven diminished culpability.
That removes the bias and creates uniformity. I love that. Second, He argues for raising the age.
Despite the science, several states still automatically treat 16 or 17-year-olds as adults for all crimes.
Still,
Yes. Feld argues that based on brain development, the absolute minimum age for adult court jurisdiction must be raised to 18 everywhere. Furthermore, he pushes us to consider extending juvenile court protections like shielded records and a focus on education rather than incarceration to young adults up to age 21 because their prefrontal cortexes are still actively maturing.
third, we have to entirely reverse the putative procedural shifts of the Get Tough era.
This means rolling back those transfer laws. Strip prosecutors of the unchecked power to direct file kids into adult court, and return that power to judges in open adversarial hearings where the child's development can be evaluated.
And what about juries?
It means finally overturning McIver and giving kids the constitutional right to a jury trial to protect against wrongful convictions. It also means strictly limiting the use of pretrial detention, which is incredibly traumatizing.
And crucially, eliminating the lifelong collateral consequences of juvenile records. A mistake made by a wildly impulsive 15-year-old should not pop up on a background check and bar them from securing housing or employment when they are a fully matured 25-year-old.
These are all highly logical, scientifically backed, and totally achievable legal reforms. But as Feld brings his book to a close, he forces the reader to confront a deeply sobering reality.
He calls it the unsolved American dilemma.
Right. Because you can tweak the dials on the legal machinery all day long. You can add juries, you can adjust sentencing fractions, you can change the jurisdiction age, but you cannot fix juvenile crimes simply by fixing juvenile courts.
Because the courts are only dealing with the symptoms after the damage is already done.
The author is starkly honest here. The root cause of the vast majority of juvenile delinquency is child poverty. If you look at the kids caught up in the system, they overwhelmingly come from neighborhoods suffering from concentrated multi-generational poverty, failing schools, and a lack of mental health resources.
And when you look at the data on childhood poverty in the United States, it is uniquely, staggeringly high compared to other wealthy Western democracies.
It is.
And as we've seen running like a dark thread throughout this entire 100-year history, that poverty disproportionately impacts children of color.
If you look at nations in Western Europe, they use robust social policies, universal paid parental leave, heavily subsidized childcare, direct children's allowances, universal health care, to effectively eradicate deep child poverty.
The United States chooses not to enact those policies.
Exactly. The ultimate barrier to fixing juvenile justice in America isn't a lack of brilliant legal theory or a lack of advanced scientific understanding. It is a profound structural lack of political will to invest resources in marginalized communities before the police are called.
So we've traveled from the idealized, paternalistic superparent of the progressive era through the procedural awakenings and civil rights battles of the due process era into the racialized panic and draconian punishments of the Get Tough era, and finally to the scientific awakenings of the Kids Are Different era.
It has been a turbulent, century-long struggle for the soul of the justice system. It is a continuous debate to determine exactly how much grace, how much understanding, and how much science we are willing to extend to a young person who has lost their way.
So what does this all mean for you listening right now?
Think about the teenagers in your own life. Think about your kids, your nieces, your nephews, or the kids down the street. When they make a terrible mistake, when that powerful limbic system accelerator takes over and the prefrontal brakes fail, your instinct is likely to see their youth. You see their unfinished potential, their vulnerability, and their desperate need for guidance.
Right.
The ultimate challenge Barry Feld's book leaves us with is a profound moral question. At what point as a society will we stop drawing a line between our children who deserve a second chance and other people's children whom we view only as a threat?
Thank you for joining us on this deep dive into the source material. We hope this exploration leaves you with new perspectives, and we encourage you to keep asking the hard questions. Next time you see a headline about youth crime, don't just react to the fear. Remember the murky history. Remember the science of the prefrontal cortex, and remember the century of societal choices behind the gavel.